Is the jail on yet? Okay.
Are you Jerry G. Howard there at the jail?
Yeah.
All right. This is case number 20CR 48, Ohio versus Jerry G. Howard. This hearing is being conducted by Mr. Howard preparing for the jail. His attorney is Daniel Witt, attorney by Zoom. Preparing on behalf of the state is prosecuting attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a third-degree felony. This is a first pre-trial, pre-trial set on May 18th. Trial was set on June 13th. I see that received bill particulars and you get your discovery as well.
Yes, sir.
Okay. Oh yeah, there it is, right? Okay. I don't see that you filed yours yet, so we filed pre-trial. Do you anticipate any pre-trial motions?
No, this time.
Okay. Well, there are any ones we got to file pre-trial. Well, has been a written plea offer provided to the defendant yet?
Yes, ma'am.
Do you mind where that is with?
Yes, sir.
Alright. Alright, any other matters need to be discussed at this time in this case?
Yes, sir.
Alright, we'll see you on the 18th, and Mr. Howard, thank you. Adam Willie?
Yes, sir.
There's some jail notes in there from somebody writing about that.
Okay.
All right, are you Adam Leon Willie? All right, this case number 22CR1016, State of Ohio versus Adam Leon Willie. Willie is appearing by Zoom. The jail is attorney is Daniel Witt, appearing by Zoom as well. On behalf of the state, the prosecuting attorney Collins. The defendant charged with failure to register a change of address as a sex offender. This is final pre-trial. I know we continued this at one time for additional investigation.
It is the final pre-trial.
Okay. All right. Is discovery incomplete?
Yes.
Okay. And there's no pre-trial motion pending, are there?
Yes.
One for this case and a couple other cases due then.
Oh. All right. Let me see where it is. Yes, leave one down there. There should be one for people that want to. Okay.
There should be four, I believe. Four police words.
Okay. He's getting it. Those people, yeah. All right, I do have more. All right, Mr. Willie, I'm looking at a plea guilty form. There's your case number and name on it. I'll hold that up to the camera on the computer. You see it there, it has your name, it says plea guilty, case number. All right. On this page, 3-page document, on page 3, about halfway down the page, there's a sentence that reads, I entered this plea voluntarily. Immediately below that, there's a signature. Here's the Adam Willie. I'll hold that up to this camera. Is that your signature there under that line? Says I entered this plea voluntarily. All right. And when did you sign this form, Mr. Willie? All right. There in the jail. And did your attorney go over this with you and explain everything to you before you signed it?
Yes, sir.
And when you signed it, do you understand that the Supreme plea guilty, which means there won't be a trial? The next step will be a sentencing hearing.
Yes, sir.
And do you think you have enough time to fully consider this matter before you sign this agreement?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Right now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to count 1, failure to register or change address as a registered sex offender under section 2950.05 F1, a third-degree felony. Further states that you understand that the maximum prison term could be 36 months for that offense. The minimum is 9, or that goes from 9 to 12, and then every 6 months up to 36 months. There's a fine level of $10,000. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction? Are you currently on duty control, probation, parole, or post-release control for a felony? Parole or PRC? All right. Do we have a notification of that in the file?
Yes, Your Honor, it was filed March 15th, 22.
March 15th. Okay. All right, here it is. According to this, was dated March the 3rd of 2022, and it indicates that at the time, that date, we had 1,144 days remaining. And so, since March the 3rd, there have been 28 days in March, 30 in April, and 4 so far in May. That'd be a total of 62 days, so subtract 62 from 1144, and we get 1,082 days. And so, under the law, Mr. Willie, if you are convicted of this offense, sent to prison, the court could also sentence you to serve the 1,082 days consecutive to where prison term is imposed. Because if you are convicted of this offense while you were on PRC, then the court can order that to be served, and does actually serve the second. Understand that? All right. Now, this is not a mandatory, sorry, let me back up. If you're convicted of this offense and sent to prison, then on completion of the prison term, it is possible that you could put under post-release control supervision by the APA. Well, this offense is not mandatory, but it is under another offense. For this one, it's optional. So if they were to put you under post-release control, it would be for a period of up to 2 years. And if during that period of time they determine that you have failed to comply with those conditions, they can return you to prison, make you serve an additional period of up to 9 months for one violation, but there's a cap, a cap of whatever prison term for all violations. But if you committed a new felony while under post-release control, then an additional sentence to judge and impose upon you for committing to a felony, and judge would also sentence you to an additional period of 1 year where time left on that period of post-release control. Whichever is greater, and if that occurs, then that's reserved the second one. to the sentence in the case, which is part of this complaint. You understand that? Now, it's not a mandatory prison offense. This offense is not mandatory. I don't have to sentence a person to prison. So I could, instead of sentencing the person, by deciding what I think to do, control, supervision under the supervision of the probation department, under the term set by the court, that should be for a period of 5 years. If they're in the period of being supervised, the probation department helps them non-compliant, then they'll file a notice of that for the writing sort of copy on you. You would be given a hearing, and you would be entitled to have an attorney to represent you at that hearing. And if the outcome of that hearing wasn't you failed to comply, then at that time, the court would vote to control essentially for 6 months, fine $10,000. Understand that? Right now, the charge in this case alleges that beginning on or about January 1, 2022, and continuing thereafter in Highland County, Ohio, you did being a registered sex offender convicted out of Highland County Common Police Court case number 15 CR 291, and according to requirements of the law in 2008, have a duty to register a change of address, failed to provide notice of any change of address within 20 days or written notice, reckless in that regard, and have previously been convicted of gross sexual imposition and felony in the 3rd degree, May 10, 2016, and being a tier 2 registered sex offender and having to do register every 180 days, 20 days before the address change. Violation section 2950.05 have one of the highlights. So that's the allegation in the charge. You understand what it is the state has accused you having done when we're now alleged you did it? And if you discuss the nature of that charge, the evidence of the case, possible legal issues of the case, possible defenses you might try to raise at a trial, and possible outcomes of a trial with your attorney, are you satisfied with your advice and confidence in this matter? Are you under the influence of any type of drugs or alcohol at this time? Are you taking any prescription drugs that are in jail? Any threat to make issue plead guilty today? Now, on page 2, there's a line and a half printed in bold and underlined that reads as follows. Defendant shall enter plead guilty to the indictment, state offense comes for 9 months incarceration. Do you understand the agreement? Anyone promise you anything other than that case you plead guilty to this charge? Under the law, Mr. Willie, the matter of sentencing is up to the judge, not the parties, so even though there's a joint recommendation from both parties that the sentence should be 9 months, if you are convicted, I do not have to follow that recommendation. I could instead sentence you as much as 36 months in prison in the increments provided by law. You understand that? You need to understand that, in addition, if you are convicted, then the court could also determine that you should be required to serve the 1,080 days, I believe, that's left on your PRC. You understand that? Now, do you hold any license or certification from any state, governmental agency that regulates any kind of a profession or occupation? Right, you have certain constitutional rights, you understand. Before you accept the plea, first of all, you have right to counsel. Ms. Witness appointed represents you, not set to work the case out, but to provide whatever defense may be available to under the law that you provide to provide. So, if you decide you do not want to plead guilty, that you want to defend against this charge, she'll continue to represent you, including a trial, if that's what you want. You understand that? All right, under the Constitution, you have a right to confront the witness against you in open court, cross-examine for your attorney. What that means is the witness against you have committed the court will testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions, that's called cross-examination. The purpose of which is to bring out evidence to help your side of the case. You understand that? And under the Constitution, you have a right to use the power of this court to compel a force witness to come to court to testify for you, just like the state. So, if you have witnesses you're not certain going to come in voluntarily to testify, you should request for release of the subpoena, which is forward. That requires those witnesses to be named in the subpoena. The court will be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one ever may testify. The prosecutor can, judgment, and you make a decision. If you decide not to testify, the fact is you did not testify. You can issue anyway, but any person at any time in the proceedings, in fact, the only reason I talk about it during the proceedings is one exception. There's a jury trial. You do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that? Under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio or every essential element of the offense charge by proving beyond reasonable doubt. What that means is that the burden of proof is on you to show that you're not guilty simply because you've been accused. In fact, you're presumed innocent. And so the burden is on the state, not you. And the burden on the state is to prove your guilt by proving beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes,
All right, now, originally you entered a plea of not guilty to the charge, there's denied the allegation, denied committing any crime, and that exercise or revoke all the rights I just described. Change your plea from not guilty to guilty, that is the opposite of not guilty. If you guilty plea admits the allegation in the event that it's a crime, that you committed that crime. That plea gives up all the rights that I have described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. Well, that exception, your plea guilty, wage gives up your right to a jury or court trial, wage gives up your right to confront witnesses against you, prosecute your attorney, wage gives up your right to use the power of the court, compel or force witnesses to be in court to testify and be the same as the state. Wage gives up your privilege and self-determination, because you're the one saying you're guilty, that's what finds you guilty. The wage gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's proposed here, most likely. And finally, if wage gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence, under certain circumstances, you can file an appeal, but it has to be filed within 30 days of your sentencing interview file. You understand all that? And are you a U.S. citizen, Mr. Willie? All right, now, do you have any questions about the charge or the possible penalties? You understand? Have any questions about the plea agreement? You understand it? Have any questions about the constitutional rights I've explained to you? You understand those? You have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today? You understand? I didn't say this at the beginning, but if you need to speak with your attorney about anything, since you're not sitting in court next to her, I can put you in her into a breakout room and talk about anything if you would like to speak with her before we go any further. Do you need to do that? Okay. And also for the record, Ms. Witt, you and your client will stipulate this hearing be conducted by Zoom rather than an in-person appearance in the courtroom.
Yes, sir.
And you're agreeing with that as well.
Yes, sir.
All right, thank you. All right. Now, Mr. Willie, you have any questions about anything that I've explained to you here this afternoon? That is, it's your decision to withdraw your not guilty plea and plead guilty to the charge as set forth in the terms of this plea agreement we just gone over.
Yes, sir.
All right, and then as to the charge, which alleges an beginning on or about January 1, 2022, and continuing thereafter in Hyman County, Ohio, you did meet the registered sex offender convicted out of Hyman County Mountain Police Court, case number 15 CR 291, according to Pharmacy Law 2008, having to register a change of address. Failed to provide notice of any change of address within 20 days of written notice, and was reckless in that regard, having previously been convicted of gross sexual victimization. A felony of third degree on May 10, 2016, then being a tier 2 registered sex offender, having to do the register in 180 days, 20 days before any address change. Violation section 2950.05, a F1 of the Fire Rights Code, a third degree felony, failure to register a change of address as a registered sex offender, carrying a possible penalty between 9 and 36 months in increment provided by law, and a fine of $10,000. How do you plead? All right, the court finds on this date of the court offense applies all the constitutional rights to make known and tell the voluntary waiver of the same pursuant to Article 11, pleading the second court trial offense not guilty of the offense of the plea. The court knows the term of plea agreement makes the underlying offense as well, and the termination court will present the copy of the present report. rest of sentencing. Anything from the state?
Other than that, he has no other convictions.
All right, Ms. Witt?
Mr. Honor, we ask the court to follow the joint recommendation. Additionally, we also ask the court to pursue this machine for the court to impose the PRC time that in this case the court does not do so. It's my understanding that this will set a bit after the 5 days, and during that 5 days, we're registering. Still going to work, and then later, also probably 5 days in the courtroom, support of Adam, taking care of the Grayson every day as well. So we just ask the court not to impose the PRC time, so that the 9 months is sufficient for the rehabilitation.
For a bill particular trial in this case? Okay. Oh, here it is. All right, Mr. Willie, anything you'd like to say?
Yes, Your Honor, I'd like to
According to the bill of particulars, you, management of the hotel indicated you checked out, prior to January the 1st, because room had been rented to contractors since that date. And the, deputy handled the registration that you received a letter on January 24th, saying that you got the register. Didn't realize you registered home. So, did you register after that? He was indicted on March 1st. Looks like he was arrested on January 19th. Okay. All right. All right. So he's picked up on the 19th. All right. So where were you between January 1 and January 19th as well? Where's that located? Okay, somebody refresh my memory. Was the victim in his defense case was that a family member? Not the sister daughter. Okay. Now, also, Mr. Willie, I have pretty bill of particulars that the officer contacted the parole officer, Ms. Wolfbarger, said she talked to you on the 5th of January, and told you that you had to return to that address. Apparently, you told her you weren't there anymore. She told you you had to return, and she had not heard anything from you after that. So why didn't you either return or go change your registration? It sounds to me like you have plenty more.
Yes, I did.
amazing attempt to turn something that's bad into something good. You know what I'm saying? Well, I didn't want to turn in the wrong address, or a address wasn't approved. The problem was you weren't even supposed to leave previous address until you gave 20 days notice in advance. But you did. You just blew it off. You weren't reporting. You weren't. You never reported on your own. They picked you up, right? No, I'm talking about when you were arrested. You were arrested on the 19th.
Yeah.
Okay. All right. Well, anything else anybody wants to say? Mr. Willie here? Yes, you're not.
I think we read a letter to the court too, and
Well, yeah, I don't look at letters, because that's part of communication. It is. You have that letter, and
Yes.
let me have that. See that, please. I don't read letters about pending cases. The other, this Walt Willie Humble indicated he was picking you up at Grayson every day, but I know he wasn't picking you up after January the 1st until the 19th, so where was he picking you up after that? All right. All right. Well, it's the order of the court to be and are hereby sentenced to the Correctional Reception Center at Royal, Ohio for a period of 9 months. And according to the sheriff, you were arrested on the 19th of January, and through today, that's a total of 104 days of jail time credit. It's the order of the court that the time remaining on PRC of 1,082 days be ordered to be served because you committed this crime while under police control, and you knew you were committing a crime. You were told to go back to that residence, or you could have just easily gone in and reported your new address. It had done it, even though you missed 20 days. They probably wouldn't have done anything, but when they have to look for you, you don't register, they look for you, they can't find you, and eventually they do. You didn't during that period of time, did nothing to address the situation. And so the court's going to order that to be imposed. I will say this, I don't normally say that, but I will indicate in my notes here that judicial release may be considered after you serve 1 year. I don't normally do that on PRC. I'm not sure I've ever given a judicial release on anybody's on PRC sentence, but in this case, you sounded like you were doing reasonably well. You weren't in trouble. It's just, you knew what you were doing here. And it's something that's all on you. And again, what happens then is that the sheriff has to look for you, charge to be brought, takes up time in the courts, an attorney or attorney fees, taxpayers' expense, court time, and here we are. And so something has to be accountable for that. And so, like I said, I can tell you that I don't think I've ever told anybody I'll consider judicial release. I made a note in my file that, well, it's not a promise you're gonna get it, but it's a note to me that when we file it, that I'll consider it, which means that most likely I'll give you a hearing, and probably 80% of the time I'm going to hearing and bring motions. But again, there's no promise. Just want you to understand that. All right. Now, upon completion of this prison term, if you serve the entire term, the adult court authority may push you under post-release control for a period of up to 2 years. And if they do, you supervise in the term they set. And if they determine that you fail to comply, then you return to prison, may be served an additional period of up to half of the prison term for one or more violations. However, if you commit a new felony like you have in this situation, then the addition, while under post-release control, in addition to whatever sentence the judge has engaged in imposed, the judge will also sentence you to committing that offense while under post-release control. In this case, to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in one case. And you also order to pay court costs, which judge can grant an excuse to order. If you don't do that, then the court could order the courts to collect that discretion fees, please let on bank, counsel, attorneys, or assets you may have. If that doesn't apply, then in addition, the court could order you to do service once you are complete, release present on water, give you credit for your child work, in an hour, you set up for your child work, you should provide that out in full. Also, your duty to register the sex offender, you'll have to report to the sheriff in 3 days after release, which county where you're going to be living, that's Hyman County. Again, that will be out of the homestead, the driveway, and the justice center. You register again, you're going to run back here again. So, I don't see that. And during the time you're in prison, that doesn't count your registration. All right, is there anything further, counsel? Okay. James Brooke Beamer was mentioned. All right, are you James Brooke Beamer? All right, case number 22 CR 0060. Table house James Brooke Beamer. Beamer is appearing by Zoom from the Justice Center. Attorney is Dennis Kirk. Where is he? He just disappeared. He apparently got signed off accident. All right, I'm gonna ask Ben to do that. And his text today, but he just dropped off the street. So give him a buzz. Something to do that.
Computer locked up, he's trying to restart.
All right. Well, Lieutenant Brown, let's go take Mr. Boothby in and ask Mr. Beaver wait in the hallway. So we don't waste time here. Oh, wait a minute, I just lost Mr. Wagner. What's going on here? Wait a minute. Well, Mr. Wagner's not on now, so let's move to. Oh, there he is. Okay. I lost you, Mr. Wagner. I thought you signed off. Would you activate your audio? We're going to go ahead and take your client. Mr. Kirk dropped off too.
The screen, but nothing
Okay. Well, something didn't happen to you and Mr. Kirk because he's dropped off. He's having a computer problem now. So we're going to go ahead and do Mr. Boothby. Alright, well, we'll go back again, we'll go ahead and see if they have to do the case or wait. Alright, this is case number 22 CR 73, State of Ohio versus Justin N. Boothby. Are you Justin N. Boothby, attorney there from the jail? Alright, Boothby's attorney is Jake Wagner. This hearing being conducted by Zoom. Mr. Wagner's attorney is off by Zoom representing the state. Her office is prosecutor Attorney Collins. Mr. Wagner, you declined both away by personal presence by the defendant in the courtroom agreed to this hearing being conducted by Zoom. You're all right with that, Mr. Boothby? All right, if you should during the hearing need to talk with the attorney or have any questions you'd like to ask me, just tell me. I can put you into a breakout room that won't be anyone else to hear or see what's going on. Okay? Defendant is charged with grand theft of motor vehicle or free felony. This is a on free trial. His trial date is set for May the 31st. The court has received a plea of guilty for Mr. Boothby, which indicates that you are going to withdraw your not guilty to the charge. I'll hold this up the camera. You can see this form there, your name and case number, plea guilty there. And on page 3, there are signature lines, and about halfway down the page, there's a sentence that says, I entered the plea voluntarily, and there's a sentence, or what appears to be signature of Justin Boothby immediately below that. I'll hold that up the camera. Is that your signature? Oops, sorry about that. There, see that? All right. When did you sign this document, Mr. Boothby? All right. Did your attorney go over with you and explain everything to you before you signed it? Did you understand when you signed it that it was going to be a plea of guilty, that there would not be a trial, that step would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully pursue this matter before making that decision? Feel that you were rushed or pressured in any way in signing this document?
Yes, sir.
And is this still your desire to go forward with this plea agreement today?
Yes, sir.
You're doing this voluntarily?
Yes, sir.
Right now, the agreement states on page 1, when you withdraw your not guilty guilty to the charge of the indictment of grand theft of motor vehicle under section 2913.02A1 of the Ohio Revised Code, a 4-degree felony, for which states you understand that the maximum penalty for that prison term imposed would be 18 months, minimum 6, would be a fine of up to $5,000. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
Right now,
And is that still pending or been sentenced there? What's the situation?
I'm in the center.
Okay, for what? For what? Okay. All right. Well, if at any time in the future, while you're serving the sentence, that case could end up in a prison term, that judge could order that to be served second to the sentence in this case. You understand that?
Yes, sir.
All right. Now, other than that charge, are you on probation, community control, parole, or post-release control from any jurisdiction for a felony?
Yes, sir.
Right now, under the law, if you are sentenced to prison for this offense and serve a prison term, once you complete that term, the adult parole authority may, at their option, put you under what's called post-release control supervision for a period of up to 2 years. It's optional, but they make the decision. The court has nothing to do with it. If they do decide you should be supervised, they will set forth the conditions and the parole officer will supervise you. And after that period of time, they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 1/2 of your prison term for one more violation. But if you committed a felony, then in addition to whatever sentence the judge, the new case can impose upon you, that judge can also sentence you for committing that violation while under community control or even post-release control in this case, to an additional period of 1 year or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right, now, Under the law, not required to sentence you to prison for this offense, and can impose what's called community control or non-prison sanctions, which means that instead of going to prison, you be put under the supervision of a probation officer for a period of up to 5 years, and during a term set by the court. And during that period of time, the probation department felt that you were not complying, then they could return you to prison even though you served, they could file a written notice of that before and serve a copy upon you. Then the court will provide a hearing and you will talk to an attorney. If the outcome of that was that you had failed to comply, at that time the court would revoke your control and then sentence you to a term of 18 months and fine you $5,000. Understand that? All right. Now the charge in this case alleges an on or about December 20, 2021, County, Ohio, you did with purchase of private Jacob Rogers and other property, and only obtained reserve control of said property with 1995 Chevrolet 1500 pickup truck, the property, being a motor vehicle as defined in ORC section 4501.01, 1000%, Jacob Rogers and other person authorized to give consent, violation section 2913.0281. So that's the charge of grand theft and motor vehicle forgery, violation with possible penalty 6 to 18 months, fine $5,000. Now, Mr. Booth, do you understand what it is the state is accused you of having done, when, where, and how they did it?
Sorry.
Do you understand what it is you've been charged with, what the state said you did, and when, where, and how they did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible offenses that could be asserted at trial, and possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
No. Yes, sir.
Have any threats made against you plead guilty here today?
Yes, sir.
Now, at the bottom of page 2, there's a 2.5 line printed in bold underline, and then there's been actually part of it's been marked out, and ink and number reserved. So I'll read that as I understand it. Defendant shall undertake guilty to the indictment. State defense will recommend 9 months incarceration. Is that correct, counsel?
Yes, sir, but Mayor, that's my Jacob there.
I saw that. I just couldn't tell. I thought that was a 9, but I wanted to make sure. Right.
Yes, this council's consent.
Right.
Yes, Your Honor.
Right. And then it says the defendant shall pay full restitution. Was that your understanding of the agreement, Mr. Booth?
Yes, sir.
They wouldn't promise you anything other than that case plead guilty here today?
Yes, sir.
All right, now, matter of sentence is up to the judge, not the parties. So even though there's an agreement between the prosecutor and you that the sentence should be 9 months, if you plead guilty, I don't have to follow that recommendation. Once I've heard all the information, could decide that that's not the appropriate sentence and sentence you to as much as 18 months. You understand that?
Yes, sir.
All right. Now, you have certain constitutional rights to understand or accept plea. Well, let me back up. Do you hold any license or certification from any state governmental agency that regulates any occupational profession? Issues a state of Ohio license for any kind of occupational profession.
Yes, sir.
Okay. Now, you have the right to have counsel in this matter. If you can't afford to hire one appointed, I did appoint Mr. White for representation. Now, his appointment wasn't simply word of case out, but provide any defense that would be able to under the law to wish him to provide. So, if you decide that you not want to do this, if you would rather defend in this case, he'll continue to represent you in trial if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to have a jury trial in this matter, which 12 people will be selected, a group of citizens that live in this county, that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, the court will instruct them on the law, and they will decide whether or not the state proved their guilt by a unanimous verdict. And unanimous means all 12 who heard after 3 are verdict. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up, which means give up in writing. The right to have a jury trial, in that case, you can have what's called a court or bench trial, which means it will be the judge instead of the jury hearing evidence. The judge will apply the law, and the judge will decide whether or not the state proved your guilt by proving out that. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witness against you and cross-examine through your attorney. What that means is the witness against you have to come in court, testify in front of you, your attorney, and anyone else is present. After prosecutor asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to try to bring on evidence to help your side of the case. You understand that? Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come to court and testify for you, like the state. So if you have witnesses you're uncertain about involuntarily, you request for these court order that's called a subpoena. That forces those people to come to court to be able to testify if they want to, even though they don't want to be here. It's the same way the state is required to come to court. You understand that? Under the Constitution, you have a privilege of self-determination, which means you're not forced to evidence in this matter at any time, including fraud. No one can ever make a testify. The prosecutor can't, the judge can't, your decision. If you decide not to testify, the fact that you did not testify, I'm used against you in any way, by any person, at any time. No one's even allowed to talk about your case, except for one situation, that is, there's a jury trial, and you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that? Now, under the Constitution, you have, or you are presumed to be innocent until proven guilty by the state of Ohio on every essential element that's charged. What that means is that the burden of proof is upon you. It's on the state. You're presumed innocent. In fact, you don't even have to present any evidence in your defense. It's not required. Whether you do or not, the burden of proof will remain upon the state to prove your guilt, prove beyond reasonable doubt, on every essential element that's charged. The highest burden of proof is known under the law. You understand that? Now, originally, interplay not guilty. Mr. Boothby, that he denied the allegation of the indictment, denied committing a crime, and an exercise or revoke all the rights I was just describing to you here today. You change your plea from not guilty to guilty, that is the opposite of not guilty. Guilty plea admits the allegation of the indictment, admits that it's a crime, and that you committed that crime. That plea waives gives up all the rights that just explained to you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea is. That exception, your plea of guilty, waives gives up. The right to a jury court trial, waives gives up the right to confront witnesses against you to cross-examine your attorney, waives gives up the right to use the power of the court, compel the court to be in court, testify for you, the same as the state, waives gives up the privilege of self-determination, because if you say you're guilty, that's what you find guilty, waives gives up the presumption of innocence, because if you say you're guilty, that's what you find guilty. It also objects you to being sentenced immediately by the court, which I think is what's being proposed here. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if you should be sentenced to the maximum sentence, under certain limited circumstances, you file an appeal. Have to be filed within 30 days for sentencing to be filed. You understand? All right. Are you a U.S. citizen, Mr. Boothby? Right, now, you have any questions about the charge of possible penalties? You understand it? Any questions about the plea agreement? You understand it? Have any questions about the constitutional rights I explained? You understand those? Have any questions about the plea of guilty, what it means, what will happen if you have that plea here today? You understand that? Anything you'd like to speak to your attorney about before we go any further? Have any questions about anything I've explained to you here today? Then, Mr. Boothby, is it your decision to withdraw your not guilty plea, plead guilty to the charge of the indictment, pursuant to the terms of this plea agreement that we just signed? All right, then as to the charge, which alleged that on or about December 20, 2021, Miami County, Ohio, you did with the purpose to deprive Jacob Rogers, the owner of property, knowing that obtain or exert control over said property with a 1995 Chevrolet 1500 pickup truck, property being a motor vehicle, as defined in ORC section 4501.01, without the consent of Jacob Rogers, the first owner person authorized to give consent, violation of section 2913.02A1, Revised Code to charge grand theft of motor vehicle, fourth degree felony, a possible prison term of 26 to 18 months, and a fine of $5,000 annually. Right, the court finds on this day of the court defendant provides all his constitutional rights and a joint public voluntary waiver of same for 11. Please accept for file defendant found guilty of this charge as set forth in the indictment. The court finds that there will be no need for a pre-sentence report, and get back to the joint recommendation, and I'll also take a look at the defendant's prior record report to the vote on the discovery, see that there's several previous convictions and also a prior prison term. And so we'll go ahead and proceed with any further from the state.
Since the statements from David, Your Honor, would advise the court that we have had contact with the victim on several occasions, however, he is not presenting now representation at this point. I do know that he has been towed, and my understanding is that he's trying to go to the tow company for the council as whatever the bill was liable. And he only had liable insurance.
There's nothing before the court term, I mean, dollar amount, sharing percent. All right, Mr. Wagner?
No, we didn't ask the party's recommendation. I know the court was had, but I think there was a national constitution request that was asked for the observer record file to test that.
Well, actually, since the state's not able to present the evidence, it'll be overdone when they'll have to pursue civil remedies. Usually plead guilty as evidence in that case, but we have that this court will lose jurisdiction.
Yes, sir.
All right, Mr. Buckley, anything you'd like to say before I pass sentence? All right. Well, as I noted, we had a previous conviction in 2009 in Brown County, period of 5, put on a plea control, violated sentence for attempt to escape out of Brown County in 2015. And then he had a leading hand trafficking that one earlier, which he got to the start program of Brown County, which is plea control. So, issue. But again, in this case, with the damage, the loss of the victim, other probable that the drug problem we have contributed to this is worthy of we have citizens that are harmed, significantly harmed, and there has to be counsel for that. So it is a judgment of the court to be in our hereby sentence to the Corrections Center, Ohio, for a period of 9 months. Report to the sheriff the rest of March 1st, is that correct? All right, so as of today, that's 63 days to be able to now, upon completion of this prison term, the adult parole authority may, their option, choose to put you under post-release control, supervision, and if they do, you'll be supervised for a period of up to 2 years by a parole officer, and if they determine that you have failed to comply, then can return you to prison, they can serve an additional period of up to after the prison term for one or more violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge, in the new case you propose upon you, the judge can also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year or whatever is left on that period of post-release control, whichever is greater. That occurs, that would serve consecutively the sentence in the case. It's also ordered to pay the court costs, the judge will grant execution order, and if you fail to do that, then the clerk, of course, can collect that reverse, including that in bank account, wages, or any other assets we have. If that doesn't collect it, then after you serve your prison term on water prison, once you complete it, then the court can order you to do service, and you can effectively carry work in an IRA set up for you carry the work to reduce your guys by that amount, and they'll pay it forward. All right, is there anything further going on, counsel?
Yes, sir.
All right, your man back up. I'm sorry, Lucy. Lieutenant, let's bring in Mr. Beamer now. I'm jumping ahead of myself. All right, we have case number 22 CR 60, State of Ohio versus James Brooke Beamer. You're James Brooke Beamer. Okay. This hearing being conducted by Zoom. We actually called the case earlier. Mr. Perkins had some sort of a computer issue and we lost him, so a different case of Mr. Perkins now present by Zoom. His office by Zoom will be prosecutor's office is prosecuting very conference. Mr. Kirk, you and your client both agreed that this hearing be conducted remotely by Zoom rather than having an in-person appearance in the courtroom. Okay, not getting your volume there, Mr. Kirk. You broke up on your mic. Yeah, there's a little bit of delay right here. Okay.
There's an echo, judge, every time I hear it, it's something.
Oh, well, that might be because of this microphone here. Let me move back in. We have a microphone, a remote microphone that we have on here to make sure it gets picked up and goes out on YouTube. So, all right, okay, all right. Sorry about that. All right, and you're in agreement with that, Mr. Beamer? All right. Now, if during this hearing you need to talk to Mr. Kirk about anything, since you're not present in court, just tell me and put the two of you in a breakout room, which should allow the two of you to converse privately, no one else being able to see you here, okay? All right, now Mr. Beamer is charged along with 3 co-defendants in a multi-count indictment. Looks like he is charged in counts 1 through 6. And this upon pre-trial and his trial date is May 31st. Now, I've been presented with a plea of guilty form, Mr. Beamer. It says you're going to withdraw your non-guilty plea to counts 1 and 3 and enter plea of guilty. I'm going to hold this up to the camera on my computer so you can take a look and see, recognize that it says that look at the left has your name as plea guilty, and there's a case number, and then there's 2 counts of plea guilty. Do you see that? All right, and would speak up and have a little trouble hearing me. Okay. On page 3, this document actually is 4 pages long, it's a little longer than others. And at the bottom of the 3rd page, there's a sentence that says, "I enter this plea voluntarily," and right below that, there appears to be a signature of change of plea. I'm going to hold that up to the camera as well and ask you to recognize that signature there at the bottom of the page under the sentence that says, "I enter this plea voluntarily." That's your signature. And when did you sign this, Mr. Beamer? Yeah. All right. And is your attorney there with you to go over with you and explain everything to you before you sign it? And when you signed it, did you understand that there's an agreement to plead guilty, which means it won't be a trial, and next step in your case will be a sentencing hearing? Do you feel that you have enough time to fully consider that matter before making that decision? And is this what you still want to do 2 weeks later? And are you entering into this agreement to plead guilty voluntarily? All right, now the agreement states on page 1, you're going to plead guilty to counts 1 and 3. Count 1 is aggravated trafficking of methamphetamine in the vicinity of the school zone. And count 3 is aggravated trafficking of methamphetamine. They're both under the same section number, 2925.03A1 of the revised code. However, count 1 is a 3rd-degree felony because of the school zone allegation, and that means that it's more serious offense than, it's more serious than it was not. Normally a 4th-degree felony, that makes a 3rd-degree felony. And then count 3 is a 2nd-degree felony because of the amount that was involved. Now, it also states that you understand that the maximum penalties for these offenses are as follows. For count 1, there's a possible maximum prison term of 36 months. There's a minimum of 9 months in prison imposed. And it can be any, there's certain ranges in between, and it goes from 9 months to 12, and then every 6 months, 18, 24, etc., up to 36 months. There's also a fine available of $10,000. There's a mandatory fine of $5,000 and a possible license suspension of 6 months to 5 years. So that's count 1. You understand that? Right now, count 3 is a 2nd-degree felony, and that possible maximum prison term is 8 years as set by the judge, and the minimum will be 2. And what that means is the judge can pick a number between 2 and 8 that the judge feels is appropriate for that offense. And that is the minimum term that has to be served. And this is a mandatory offense, And so, mandatory sentence, I should say. So, whatever sentence that I give you, between 2 and 8 years, you have to serve. There's no if, ands, or buts about it. Now, under the law as it currently exists, it's being challenged, but right now it's still in effect, Reagan Coast Law. That provides that persons convicted of serious felonies, in this case, a secondary felony, is one that is covered by that law, that the sentence that the judge says is what has to be served under the law. But then the Department of Rehabilitation and Corrections can decide, based upon their analysis of the individual and the offense and risk and so forth, that the term set by the judge should be extended by up to 1/2. And so, and again, the court doesn't have anything to do with that, that's strictly up to the DRC. So, what that means is that the maximum term that I can impose if you plead guilty is 8 years. And that could be, if that were a sentence, then that could be that it would be extended up to 12 years, because 4 is after 8, and 8 4 are 12. You understand that? And now, that only applies to the second count, it doesn't apply to the first count. Now, under the law, if you're convicted of both these offenses, the court could sentence you to consecutive prison term, which is generally the practice of this judge. And so, what that means is that you have an 8-year maximum on count 3, and a 36-month or 3-year maximum on count 1, and certain between 11 and 15 years. You understand that? Okay. Now, count 3, there's also a fine available up to $15,000, and there's a mandatory fine of $75,000. And both offenses carry a possible license suspension between 6 months and 5 years. You understand that? Now, other than these 2 charges, Mr. Gamer, are you facing any felony charges anywhere else? And are you currently on probation, community control, parole, or post-release control for a felony from any other jurisdiction? Now, under the law, if you are sentenced to prison, well, you have to be sentenced to prison. There's no option sentence. So, under the law, count 3. Once you complete the prison term that is imposed by the court, and any other additional time up to 50% that might be required by the DRC, once that happens, and plus the other sentence on count 1, once you complete that prison term, you will be placed on post-release control for a period of 3 years. Minimum of 18 months and a maximum of 3 years. As to count 2. Now, as count 1, it's optional up to 2 years, but because we know it's going to be on count 2, that will be the one that they'll use. And so that means you'll be supervised on a term set by the adult parole authority, not the court. The judge has no involvement in that by parole. And if they determine while you're under that supervision, again, at least 18 months, within up to 3 years, that you have failed to comply, they can return you to prison. Make you serve an additional period of up to 9 months for a single violation, up to a half or limit of half of the prison term for all violations. But if you committed a new felony while under post-release control supervision, then in addition to whatever sentence the judge in that new felony case proposed, that judge would also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year. Whatever time might be left on that post-release control between 18 months and 3 years, whichever is great. And if that happens, then that has to be served consecutively with the sentence in the case. You understand that? Alright? Now, because count 3 is a mandatory sentence, there's no possibility of committing control, and then based on action, we'll get control count 1 on it. You understand that? Okay. Now, the first count alleges that on or about March 16, 2021 in Dining County, Ohio, Lee Aubrey Eugene Robinson, Andy Lynn Young, and you did knowingly sell or offer to sell methamphetamine Schedule 2 controlled substance in the vicinity of the school zone, violation section 2925.381. That's the third count. Then count 3 alleges that on or about March 19, 2021, Hunter County, Ohio, that Plea, Aubrey, Eugene Robinson, and Lynn Young, and you, excuse me, did knowingly sell or offer sell methamphetamine and schedule 2 controlled substance, an amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, in the city of school zone, violation section 2925.0381. And so that is a secondary felony. Mandatory prison term, like I said. Now, you understand what the charges are, what the possible penalties are, Mr. Freeman? And you understand what the state says you did each of those counts, when, where, and how they alleged you did it? Have you discussed the nature of each of those charges, the evidence in each case per count, the possible legal issues as to each count, possible defense you should try to raise as to each count, and possible outcome of the trial for those 2 counts with your attorney? Are you satisfied with his advice and confidence in this matter? Are you under the influence of any types of drugs or alcohol at this time? Are you taking any prescription drugs there at the jail? Now, have you been threatened in any way to enter into this plea agreement? Right now on page 2, about halfway down, there's a 3.5 lines printed in bold and underlined. So I'll read those at this time. Defendant shall order plead guilty to counts 1 and 3. The state will dismiss the remaining counts. State defense jointly recommend 24 months in count 1, consecutive 2 years in count 3. State will not oppose judicial release for drug treatment. Defendant agrees to pay restitution amount of $600. That's your understanding of the agreement? Does anyone promise you anything other than that to issue the guilty here today? Now, I want you to understand on judicial release, because of count 2 being mandatory, you have to serve the entire 24 months. You cannot get judicial release on that. You could then apply for judicial release on the sentence on count 1 once you become eligible for that. So it'll be a while before you can be released if you are released. You understand that? Okay. Which brings me to my next point, and that is the matter of sentencing is up to the judge and not the parties. So even though there's an agreement as to what the sentence ought to be, the court's not required to follow that. So if you plead guilty, I don't have to follow this recommendation. I could give you 8 years mandatory count 2 and 3 years on count 1, second for a total of 11 years, plus the possibility of an additional 4 years on count 3 as determined by the DRC. You understand that? Same thing also holds true regarding judicial release. Just because the state says it's not going to oppose your judicial release motion when you're eligible to file it, which can be over 2 years, that doesn't mean that you're going to get it, because that decision is up to the judge. So if you plead guilty in our sentence and file for judicial release, the court is not required to grant it to you. That decision will be made based upon the information that was submitted at that time. You understand that? There's also agree to pay $600 for restitution. That amount is stipulated, Mr. Kirk. Okay. All right. Now, other than that, has anyone promised you anything to get you to plead guilty here today? All right. Now, do you hold any license or certificate from any state governmental agency that regulates any type of profession or occupation in the state of Ohio? Right, you have certain constitutional rights to understand before I can accept your guilty plea. You have right to counsel. Mr. Kirk is appointed to represent you. Now, under the law, I didn't appoint him simply to have to work the case out for you. His appointment was to provide any defense could be available to you under the law which you would like to provide. So, if you decide you do not want to plead guilty, that you want to defend against these charges, he'll continue to defend you, represent you, including a trial, if that's what you want. Do you understand that? All right, now, under the Constitution, you do have a right to have a jury trial in this matter, which means that 12 people will be selected from a group of citizens that live in my county that are subject to jury duty in their trial. And then those 12 people will be the jury. They hear the evidence, be instructed on the law. And then that jury would have to decide by a unanimous verdict between all 12 that have agreed on whether the state proves or guilty on either of those charges. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive the right, which means give up, waive means give up. Your right to have a jury trial. In that case, we have to call it for a bench trial, meaning instead of the jury hearing the evidence, the judge hearing the evidence, apply the law, decide whether or not to stay proof or guilt on either charge. You understand that? Well, the law, you have a right to turn the witness against you over court and to cross-examine them through your attorney. What that means is that the witness against you have to commit to court and testify in front of you and your attorney and anyone else may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence of help for your side of the case. You understand that? Now, in the Constitution, you have a right to require the court to compel or force witnesses to come to court to testify on your behalf for the same mistake. If you have witnesses that you want to testify, that you're not certain want to come in voluntarily, your request, there's a subpoena issue, which is a court order, and that forces those people that are making the subpoena to come to court and testify on your behalf if you want them to, even though they don't want to be here. That's the same way the state's witnesses, of course, come to court. You understand that? Right now, in the Constitution, you have a privilege against self-incrimination, which means you're not reporting evidence in this matter anytime, including the trial. No one can ever make a testimony. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation, that is, if there's a jury trial and you want to testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that? Now, in the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of each charge. So what that means is that the burden of proof is on you to try to prove you're not guilty simply because you're accused. In fact, under the law, you don't have to present any evidence at all if you're in defense. You may, it's not required to. Whether you do or not, burden of proof will remain on the state, prove your guilt on every essential element of each of these charges by proof beyond a reasonable doubt. That is the highest burden of proof is known under the law. You understand that? Now, originally you entered plea not guilty. Mr. Beamer, that plea denied the allegation and the indictment denied you committed a crime and exercised or invoked all the rights that I just described. You change your plea. Not guilty to guilty, that's the plea out to the not guilty plea. Guilty plea to this allegation in the indictment, admits that they're a crime, and that you committed that crime, as to these two charges. And that plea waives or gives up all the rights that I just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, with that exception. Your plea of guilty waives or gives up your right to have a jury or court trial, waives or gives up your right to confront witnesses against you and cross-examine through your attorney, waives or gives up your right to use the power of the court to compel or force witnesses to be here to testify for you, just like the state, waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what defines you guilty. And waives gives up your presumption of innocence, because if you say you're guilty, the state does not require to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely to happen here today. And finally, it waives gives up any right to file an appeal, which you think you could have had up to those point of the case. Now, if I sentence you the maximum sentence or under certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing after being filed. You understand all of those things? Are you a U.S. citizen, Mr. Beamer? All right, do you have any questions about either of these two charges or possible penalties? You understand them? Do you have any questions about the plea agreement? You need to speak up. And you understand it? Do you have any questions about the constitutional rights I've explained? You understand those? Do you have any questions about the plea guilty, what it means, what will happen if you enter that plea here today into these two charges? You understand? Now, is there anything you'd like to speak to Mr. Burke about before we go any further? Do you have any questions about anything that we've talked about here this afternoon? So is it your decision then to withdraw your not guilty plea, plead guilty to counts 1 and 3, pursuant to the terms of the plea agreement that just got over? Okay, then as to count 1, which alleges that on or about March 16, 2021, Highland County, Ohio, that you, Malik Aubrey, Eugene Robinson, Andy Lynn Young, you, did knowingly sell or offer to sell methamphetamine, Schedule 2, controlled substance, city school zone, violation section 2925, .0381 of the Ohio Revised Code, a third degree felony, carrying a possible prison term of between 9 and 36 months in the increment provided by law, a fine of $10,000, a mandatory fine of $5,000, on license suspension 6 months, 5 years, how do you plead? As to count 3, which alleges that on or about March 19, 2021, Nottingham County, Ohio, the lead auditor Eugene Robinson, Amy Lynn Young, and Jane Beaver in the cell or off the cell methamphetamine expected to control substance found in the receive 5 times walk down plus 5 times walk down in school zone, this is 29.5.381, which is actually also the same charge that's left out in the plea guilty form. It is also aggravated traffic, but in the school zone.
You see it says amended because we reduced it from the F1 to the F2 by taking out the incentives.
Okay, it doesn't say it is amended here.
It doesn't say on the front page, right?
No, it doesn't say that in the language in the red either on page 2. So that's why I was wondering. I didn't see that. So that was originally a first degree felony. Let's see here. Okay, I see that. All right. So then, Mr. Kirk, you understood that this was amended down from an F1 by deletion of the school zone. Okay. Well, the no procedure leads back to the fact it wasn't on the form, so I didn't realize that. I just want to make sure there's no problem. All right. So, with that clarification, since I didn't understand that what I could read, that is also just aggravated traffic, count 3, but it's still a second degree felony instead of a first degree felony with possible term. Can you understand that then, Mr. Beamer? All right. And so how do you plead that charge? Okay. As well as capital. Okay. All right, the court finds on this day open court defendant with bylaws, constitutional rights, and a joint health voluntary waiver saying pursuant to Article 11. Plea is accepted for the file. Defendant is found guilty of counts 2 from 1 and 3. Counts 2, 4, 5, and 6 are dismissed as to this defendant. Defendant is found guilty of counts 1 and 3 as charged therein. These pleas are filed. Now, because this is a mandatory prison term as count 2, there's a joint recommendation. The court is not going to order a pre-sentence report. Now, pursue sentencing for the anything from the state regarding the section?
However, and kind of hard for listeners to speak of, however, he's definitely jumped in the deep end with what he's done here. He's charged with ethical offenses, not just because of the but maybe what he was hoping to facilitate. People like people were taken down, they started in Minor County. So, which is also a problem. That being said, he is very proud of history. So now the question of the great future is assignment. What aspects of 2 years being curriculum count 3, the 24 months of count 1, and the state not really district after the 2 years of time and or restitution that you are here.
Sure.
When I explain that the ability to apply for judicial release does not mean they don't get it, but if he does go to prison, that's certainly going to help the odds. And he understands that it's best over the bigger.
Alright, Beamer, anything you'd like to say? Alright, well, I encourage to know that you didn't learn to crawl before you walk. You went right ahead and walked into a major, felony offenses here right off the bat, so, taking out into consideration that you order judge of court to be sentenced as count one to a term of 24 months in the correctional reception center, or in Ohio, as count three to a mandatory term of 2 years. Those sentences, which would also be increased up to 3 years by adding 1/2 of the combined total of the court, should the DRC decide to do that under regular law. Those sentences are to be served consecutively to one another. The court determines that these offenses committed are of one course of conduct, and that one single prison term will not adequately reflect the seriousness of the offenses and terms that be imposed are not disproportionate to the harm caused. The 2 years of count three period the minimum sentence, and the sentence of count one being slightly more than half the possible action. And court feels it is necessary for protection of the public, police, penetration of criminal conduct again, although we refer to that offenses given the amount and nature of the offenses that they affect public future crime. Now, according to the sheriff, you have, I think the rest of March 1st or March 8th, is that correct? All right, so you'll be given 57 days of jail time credit from today, as of today. Now, upon completion of the prison term as count three, if you serve the whole time, but you don't get your judicial release, or if you never get your judicial release and go back and like violated it, so end up serving the entire term. On completion of that term, it is mandatory if you put under police control count three for a period of 18 months, minimum of the maximum of 3 years, and count one is optional up to 2 years. Now, we can be supervised in the term set by a parole authority by a parole officer during that period of time. The term that you have failed to comply, they can return you to prison. We can serve a additional period up to 9 months for one violation, up to a maximum of half of a prison term that the court imposed, which would be 2 years for all violations. However, if you commit a new felony, all under post-release control, then in addition to sentence the judge in that new felony case is closed by, then the judge is also authorized to sentence you to an additional period of 1 year or time left on the post-release control, whichever is greater, or committing the new offense on the post-release control in this case. You're also ordered to pay $600 for restitution. Hines County Drug Task Force that will be payable to the Hines County Witness restitution account, and you will be required to pay any service fee they charge for providing that service. Now, you also order to pay the court costs, which judge grant execution's order. You have to do that. And the clerk, of course, would like that to be very include that in the bank account with the terms and addresses you have. That doesn't collect it, and upon completion of your prison term, not while you're in prison, once you have, we permitted to do community service in this county, and you get the credit for each hour you work in an hourly rate set by the court. Each hour you work, you should judge by that amount until paid. All right, is there anything further from council? I did not say that, thank you. Has there been any change in financial circumstances since I appointed council for you? Mr. Beaver? Have you had any change in your financial situation since I appointed counsel for you?
Yeah.
Okay, well, what I meant is for better. In other words, if you inherited money, or anybody gave you a winning lottery ticket or anything? Alright, well then the court will find that you do not have engaged to pay the mandatory fines, or will you like in the future, so those fines are paid. Alright, anything further? Alright, thank you. You're remanded back to custody. Alright, Lieutenant Brown, we need Nathan Walker. Case number 22 CR 84, State of Ohio versus David Alexander Walker. David Alexander Walker occurring from jail. Okay. The hearing is being conducted by Zoom. Walker appearing in the jail, his attorney is Captain Hamner, appearing in her office, appearing in the prosecutor's office is Prosecutor Attorney Collins, defendant's charged with aggravated trafficking and methamphetamine in the vicinity of the school of second-degree felony and aggravated possession of a third-degree felony. This plea is a first pretrial, final pretrial set on May 18, and trial set for June 13. I see that the state has provided discovery as well as a particular, that Ms. Hacker also has responded. Any further discovery, Council Guerrero? All right, discovery is complete. Are there any pretrial motions anticipated, Ms. Hacker? All right, well, if that changes, you should file those up to the day of the pretrial. Has been a written plea offer provided?
There has been, I have gone over that, with my client, and he is aware of the offer, and he is considering it at this time.
Okay. Are there any other matters that are discussed at this point?
No.
All right, we'll be seeing you then in 2 weeks, Ms. Walker, thank you. All right, Belvin McKenzie. Case number 22 CR 88, State of Ohio versus Melvin Michael McKenzie. Are you Melvin Michael McKenzie appearing there in the jail? All right, this hearing is being conducted by Zoom. Hearing on behalf of the defendant, his office is Attorney Dennis Kirk. Kirk, you're on mute there. Hearing on behalf of the state is Prosecutor Attorney Collins. This is a first pretrial, I believe, and the final pretrial set for June 1. Trial date is set for June 13. All right, I see the state provided discovery and a bill of particulars, and I don't see your discovery yet in the file, Mr. Kirk. Have you provided that yet? All right. Well, it'll be due by the final pretrial, and you anticipate any pretrial motions? All right, well, those, if you find any that are appropriate, you can file those by the final pretrial as well. Has there been a written plea offer provided? You're quite aware of that, Mr. Kirk?
Yes.
Okay. All right. Are there any other matters that will be discussed at this point? All right, we'll see. Yeah.
With this report to review the law, and it was set at 10,000 right now, no question, let me make that, sitting down and talking with the kind of people who's been prior, there for years, or any issues with, parents support, the case we can be able to do with his mother, and that business experience with mother, property, just has to work for people.
Collins?
But I believe that, the city didn't have a failure to appear per se, but I believe that the violation that got him sent to prison was found in the report. I was the first that I remember the day that he got sent to prison. And I'm 99% sure it was for failure to report.
All right. Is his mother the subject of the Board of Health case? Yeah.
No, co-defendant's license.
Oh, it's his wife?
It's co-defendant's license.
Oh, his code. No, Yoda, Nalani Hens or something, that's your mother?
Yes.
All right. Because when he said to take care of the property, he's doing a real poor job. She's here, the poor order to clean it up, so, I would see that, releasing him for that for sort of any benefit to anyone. But given the nature of the charges and the defendant's prior history, the revocation of control of court will not be involved. Thank you. Okay, well, I know we've had his mother in on contempt the other day. I don't recall, oh yeah, was that Sharon Hatfield?
Yes.
I think we just had her yesterday. I didn't realize it was a relation. All right, thank you. All right, Roger Gruber, please. Case number 22CR020, in Ohio versus Roger Gruber. You, Roger Gruber, Roger Lee Gruber. All right. This hearing is being conducted by Zoom, and Mr. Gruber's attorney is Dennis Kirk, who's appearing from his office, and then appearing on behalf of the state of prosecutor's office, Prosecutor Collins. This hearing is being conducted by Zoom. Mr. Kirk is the client both agreed to the appearance of the defendant before the court by Zoom rather than in person appearance in court.
Yes, true.
You agree with that, Mr. Gruber?
Yes.
All right. Mr. Gruber is charged along with 6 co-defendants. There's a total of 33 indictments, but I think he only is charged in count 23 and 24. And matter is set for trial, I believe, the end of this month. May 31st. All right. Now, Gruber, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea guilty to count 3. And I'll hold that up to the camera so you can see. Make sure you recognize that has your case number, your name on it. It says plea of guilty and it shows count 1 and 3 there. Recognize that?
Yes.
And on page 3, there are signature lines on this form. Actually, this is on page 4. And there's a sentence right at the top of the page that reads, I enter this plea voluntarily, and then immediately below that, there's a line that says signature of defendant. Now, I'll ask you if those lines that I'm looking at on that line, is that your signature?
Yes, that's awesome.
Okay. When did you sign this document, Mr. Gruber?
Earlier today,
All right. Did he go over with you and explain everything to you before he signed it?
yes.
You understand that it's agreed to plead guilty, which means there won't be a trial. The next step in your case will be a sentencing hearing.
Yes.
And do you feel that you have enough time to fully consider this matter before making that decision? Do you still want to go ahead and go forward with it here this afternoon? And are you entering into the agreement to plead guilty voluntarily? Agreement says you're going to plead guilty to count 23 of aggravated trafficking, methamphetamine, in the vicinity of the school zone, and 2925.03A1, a secondary felony. Further states that you understand that the maximum penalty for that could be up 8 years in prison. Now, the judge has the authority to sentence as a minimum 2 years, and any number between 2 and 8 years. And whatever sentence the court proposes is a mandatory sentence. There's no judicial release or early release or reduction. Could be no community control. It's a mandatory term. And then after that term is served, it is possible under the current law, American Post law, that if the DRC, Department of Rehabilitation and Corrections, determines it appropriate, they can extend that sentence based upon their analysis of your situation and your past and the risks that you might pose, that they could decide to extend the murder sentence for the post by up to 1/2. So what that means is the maximum minimum term could be ordered by the judge is 8 years. If that were the sentence, then it could be up to 12 years because the DRC could keep you for another 4 years if they thought that was they could do under the law. You understand that? There's also a fine of up to $15,000 possible. There's a mandatory fine of $75 and a possible license suspension of 6 months to 5 years. You understand that?
Yeah.
All right. Now, I know you're serving a prison term right now. What is that? How big of that charge? Okay. Well, other than that charge sentence, are you facing any felony charges anywhere else? Are you on probation or community control, or post-release control, or parole for any other charge beyond the lingering imprisonment outward and any other thing? Okay. All right. Well, under the law, if you plead guilty to this offense here and are sentenced to prison, that sentence could be ordered to serve consecutively with the sentence in the new case or in the old case that you're currently serving. So as we extend your outtake on whatever time the court sentences you to, plus an additional time DRC might be. Understand that? All right, now, under the law, once you complete the sentence imposed by the court, the adult parole authority will be required as part of the sentence to put you in post-release control supervision for a period of at least 18 months, up to a maximum of 3 years if they return. You'll be supervised on the terms they set because the court is not involved with that at all by parole officer. And if they determine that you have failed to comply with those conditions, they could return you to prison and they can serve an additional period beyond that that's already been served for up to 9 months of any single violation. But there is a cap or limit on the cap for whatever prison term forward for all violations. However, if you commit a new felony while under post-release control supervision in this case, then in addition to whatever sentence would be imposed by the judge in that new case, the judge could also sentence you for committing that new offense while under post-release control supervision in this case to an additional period of a year, whatever time on that 18-month, 3 years post-release control is ever is greater. If that occurs, that would be served consecutively with the sentence in the new case. You understand that? All right. Now, and again, the part on your plea form is community parole for district now because you're not eligible for community parole probation. You understand?
Yeah.
Okay. All right, now, the charge in count 23 alleges that on or about July 9, 2021, in Highland County, Ohio, Jennifer R. Ison and you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount less than 5 times bulk amount in the vicinity of the school zone in violation of Section 2925.03. So again, that is the secondary felony with a mandatory prison term of between 2 and 8 years supported by the judge, a maximum of up to 1 half of whatever term imposed by the judge and added on by the BRC. A fine of up to $15,000, possible mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. Now, you understand the charge and possible penalties for committing that offense. Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you try to raise at trial, possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with the advice and comments of the defendant?
Yes.
Are you under the influence of any type of drugs or alcohol at this time? Are you taking any prescription drugs?
Yes.
Have any threats been made against you to plead guilty here today? Now, on page 2, there are 4.5 lines that are printed in bold and underlined, so I'll read those at this time. Defendant shall plead guilty to count 23. They dismiss their remaining counts. State defense joint recommend 2 years of mandatory incarceration. Defendant agreed to pay back money joint and 5 money joint, several with Jen Rice in the amount of $4. Consideration plea. Defendant will cooperate fully with HCPA, which is the Lake County Task Force, including testifying if necessary. That's your understanding of the agreement.
Yes.
Is there any anything other than that case you plead guilty here today?
Okay.
Under the law, the matter sentence of the judge, not the party. So even though there's a recommendation to get the minimum sentence, if you plead guilty, I don't have to follow that recommendation. I could decide that the sentence should be more, even up to 8 years at the minimum, mandatory, if I decide that's the appropriate sentence. You understand that?
Yeah.
Now, do you hold any license or certification from any state, governmental agency that regulates any kind of occupational profession? But that's been since you've been in prison? Okay, not at the time of this offense. Alright. Because if you were, I'd have to notify the department, since you made that sentence to the non-department. Now, you have certain constitutional rights you must understand before I can set a plea. First, your appointed Mr. Kirk represents you. That wasn't simply to work the case out and provide any defense time be available to you under the law to which you apply. So if you decide you don't want to plead guilty, but you want to defend these charges, we'll continue to represent you, including trying the case if that's what you want. You understand that? Right now, we have a right to have a jury trial in this case, Gruber, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury to be on your property. After they are selected, the evidence will be presented. The judge will instruct them on the law, and then that jury will decide on a mandatory, 12 of them have to agree on whether to say true or guilty. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you could waive in writing, which means give up the right to have a jury trial. At that time, you would have what's called a bench trial, meaning that instead of the jury hearing the evidence, it would be up to the judge to hear the evidence by the law and decide whether or not to say true or guilty. You understand that? Right now, under the Constitution, you have the right to confront witnesses against you in open court and cross-examine them through your attorney. That means that the witnesses against you have to come in court and testify in front of you, your attorney, and anyone else is present. After the prosecutor done asking questions, your attorney asks questions, that's called cross-examination, purpose of which to bring out evidence and find out the case. You understand that? Constitution, you have the right to be part of this court, compel witnesses to be in court, testify on your behalf, state to state. So if you have witnesses you're not certain want to come in voluntarily, if your request for court orders called subpoena, that would force those witnesses to come to court and be able to testify if you want them to, even though they don't want to be here, which is the same way the state witnesses are required to come to court. You understand that? Right now, under the Constitution, you have a privilege against self-incrimination, which means you do not report or give evidence in this matter at any time before the trial. So don't intermediate testify. Prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact is you did not testify, not be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation, that is, if it's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that? Right now, under the Constitution, you are presumed innocent to prove guilty by the state of Ohio on every essential element of the defense charge. What that means is that the burden of proof is upon you to try to show you're not guilty simply because you're accused of this crime. In fact, under the law, you don't have to go on any evidence or defense at all. Today, it's not required. Whether you do or not, the burden of proof will remain on the state to prove your guilt and prove beyond a reasonable doubt on every essential element of the defense charge, which is the highest burden of proof is known under the law. You understand that? Right now, originally you entered a plea of not guilty plea, denied the allegations in the indictment, denied you committed the crime. That plea with an exercise or both all the rights of the described. Change your plea from not guilty, that's the complete opposite of not guilty plea. Guilty plea, if there's allegations in your indictment, there's a crime, you're one committed that crime, that plea waives gives up all rights that are described. They accept the right to have an attorney, which you always have no matter what you plea. That exception to plead guilty, waive give up the right to have a jury or a court trial. Waive give up the right to confront witnesses against you and cross-examine through your attorney. Waive give up the right to use trial or court, compel or force witnesses to come to court, testify for you, same as the state. Waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what she finds you guilty. Waive gives up presumption of innocence, because if you say you're guilty, then the state is not required to prove you're guilty. It also subjects you to being sentenced immediately by the court, and finally, it waives gives up any right to file an appeal if you think you could have had up to this point in the case. Now, should I sentence you to the maximum sentence, run those certain circumstances, you file an appeal, that would have to be filed within 30 days if you're sentencing it to be filed. You understand all of that? Are you a U.S. citizen, Mr. River? Right, do you have any questions about the charge or possible penalties? You understand? Again, you understand that it's a mandatory prison, there's no option for any community control or early release. You have any questions about the plea here? You understand it? Any questions about the constitutional rights of this claim? You understand those? Any questions about pleading guilty, what it means, what will happen at the end of that plea here today? You understand that? Now, do you have any questions you need to ask your attorney or anything you'd like to speak to your attorney about before we go any further today? Have any questions about anything that I've explained here today? All right, then as to the charge in count 23, that alleges that lost my place here. that on or about July 9, 2021, in Ryan County, Ohio, that Jennifer R. Ison and you did knowingly sell, offer, sell methamphetamine, schedule 2 controlled substance, and amount equal to or city involved amount less than 5 times involved amount in the city school zone. Violation section 2925.0381, a secondary felony, carrying mandatory prison term between 2 and 8 years, with the possibility of that being extended by up to 1 half by the BRC. A possible fine of $15,000, mandatory fine of $7,500, and possible license suspended for 5 years. How do you plead? All right. Court finds on this date of court, defendant provides all his constitutional rights made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Please accept it in court of trial. Defendant is found guilty of count 23, as charged therein, a secondary felony. Count 24 is dismissed. Inasmuch as this is a mandatory prison sentence and the defendant is already serving a prison term, there will be no pre-sentence investigation order. The court will proceed with sentencing. Anything from the state regarding sentencing? All right, Mr. Kirk.
Since arriving in prison, he reports to me that he was, when I say sentencing, I guess I mean before he was sentenced in prison.
I understand. Yeah, I understand.
Since reporting to prison, he reports to me that he did learn the skill of a barber. He also apparently had mechanical skills already, and he put those skills he's been a mechanic in the prison shop. Of course, he has no tickets to rent us. So, but as for the agreement and 2 years.
All right, Mr. Gruber, is there anything you'd like to say? All right, well, it is ordered judgment of the court that it should be sentenced to a mandatory term of 2 years incarceration at the Correctional Center of Central Ohio. And that sentence is ordered to serve the second week sentence to return to serve. The reason for that is this deal that's once been involved in control of the previous case, and would also know you have looks like 3 prior felony conviction, and therefore the prior criminal history is such that an executive term is necessary to protect the public. The court also finds that the harm that this person committed, crime committed was part of 2 separate courses of conduct, and 1 single prison term not acted to reflect the seriousness of the offenses of the harm caused, and that the term is being imposed not disproportionate to the seriousness of the crime. In fact, it's a minimum sentence. Now, that sentence could be extended by 1 half by the BRC, make it up 3 years. On completion of the prison term, Mr. Gruber will be put under post-release control supervision by the adult parole board as required by law for a period of at least 18 months up to a maximum of 2 or 3 years. And if during that period of time, ABA determines that you have failed to comply, they can return to prison, they can serve a additional period of up to 9 months or 1 violation, up to a maximum of half of the prison term of 1 year for all violations. However, if you commit a felony, while under post-release control supervision in this case, in addition to whatever sentence that judge in that new case would impose, and it also sends you to additional period 1 year where the time left on in the post-release control. In this case, whichever is greater, if that occurs, that will have to serve the second sentence in the case. Important, only sheriff in here 2 days every day, so that the, and any other time we hear that it was sent back to prison will be credited to that sentence. Now, we also would pay court costs for judge granting future court, we have to do that. Court might have to verify the level bank accounts with we have. That doesn't let that on completion of the prison term online, they can shoot out. court could have you do service in this county, you could each area work, I know it's at the court, each area work, produce your judge by that. You're ordered to pay $240 jointly separately with Jeff Price and Cook Bennett, to the Lyon County, task force, and that's to be paid, through the witness escrow account and pay any, fee associated with that case. All right, is there any further counsel?
Guys, the kids are having jail time credit for this case, correct?
2 days.
Okay, I'm sorry.
Oh, also, there won't be any driving suspension. Did you, have you had any change in financial circumstances since you were in prison and counsel support in this case? Mr. Have you had any improvement in your financial condition since you went to prison? Okay. And the court will find that you do not have the means to pay the mandatory fine, or will you likely have in the future, near future, therefore the court waives the mandatory fine. All right, you're man back to custody. Thank you. All right, I think the last one we have in jail is Jesse Vinegar. What's that? I think he goes back to prison, wherever you got him. Yeah. Vinegar, Jesse Vinegar. Are you coming over to court to handle the in-person case in this office? Or Mr. King? All right.
Yeah, Mr. Keenan, okay.
All right.
Great, if I could adopt it, I'm saying, no, adopt it.
Yeah, to get the email with the list in order. Yeah.
I'm being part.
Yeah, no. My dad used to say, "Get worth of water, you can't make it dirty." All right, this is case number 22 CR 40, State of Ohio versus Jesse Milton Vinegar. Are you Jesse Milton Vinegar appearing there for the jail? All right, this hearing being conducted by Zoom. Mr. Vinegar appearing in jail, his attorney is Daniel Litchie appearing by Zoom. Also appearing on behalf of the state by Zoom as a prosecutor Collins. Defendant charged with aggravated trafficking and methamphetamine in Cincinnati School, and also aggravated methamphetamine. The final pre-trial had trial date of May 31st. Now I know I was looking through the file and I see charges complete state and the notification of it. And I know this is the first time you've seen him face to face with Liz. Have you applied for discovery yet?
Right there, I'm discussing these, and I just showed the right time, I said, so we can, there's tomorrow or Friday.
All right. All right, well, then we'll continue this hearing in progress until, Sam, are you still be here Friday morning?
I have not yet.
Oh, no, I'm talking about this way, I'm sorry.
No, I didn't. I'm not, but I'm thinking.
All right. So you're here, what, 9? I think Mr. Wagner's gonna be here at 10. So how about 11 o'clock Friday morning? You go there. All right, we'll continue this hearing until Friday. That will be, May, 5th, or 6th, at 11 a.m. And, it gives you a couple of days, so easy to talk to him. All right, so Ms. Wood will be out to talk to you, Mr. Vinegar, and then we'll, have another, hearing Friday morning. Okay? All right, thank you. All right, I believe that concludes all the Zoom hearings, so we'll go ahead and shut them down. Just all over. And let me wait.
Please rise. Be seated. Who did you call?
Caesar.
Oh, sir. Okay.
Good afternoon, Your Honor. Will Parker on behalf of Mr. Caesar.
Case number 22 CR 86. Responsibility of James on behalf of the state, Dr. Tom, on behalf of the Attorney Parker. You are Billy J. Suter.
Yes.
Suter is charged in first county indictment, aggravated traffic this in the school zone, aggravated possession of methamphetamine. This is a first pretrial, non-pretrial set on May 18th, trial date is 13th. See the state's compliant with discovery of 19 and particulars. Now, Mr. Parker, you see those?
I have, Your Honor.
Your discovery due by the final pretrial. You participated in the pretrial motion.
Your Honor, I did file a motion to reveal confidential informant's identity that was filed today. I understand that will be done until a couple of weeks before trial. Additionally, I was looking on the court's website, could not find co-defendant prior to coming before the I'm assuming those trial dates are set on the same date. If that is the case.
He hasn't been picked up yet.
Take up.
Okay, and that'll get rid of one motion, but there may be a motion possible regarding another buy, but after I speak with Prosecutor Collins, that may be an issue.
All right. Well, that'll be, any pretrial motions that be due by the final pretrial. And has been a written day on the provider?
There has been, Your Honor.
You're not aware of that again, Mr. Burke?
He is right.
All right, are there any other matters that need to be discussed?
This time.
Your Honor.
All right, we'll see back to that on the 18th. Thank you.
I know where he's at.
Austin David Trent. Case number 21 CR10, State of Ohio versus Austin David Trent, federal behalf of state, Senator Collins, federal behalf of defendant attorney Daniel Witt. And are you Austin David Trent? Right?
May I switch?
Okay. Defendant charged with 2 counts, 1 trafficking and 1 possession of LSD, both for felonies. This is a retrial, I believe. Retrial Friday of May 31st. Representative legal form, Mr. Trent, indication going to recall your non-guilty plea, guilty 2 and 1. This is a 3-page form the prosecutor's office prepares. On page 3 there are signature lines. Halfway down there is a sentence reading, I heard the plea voluntarily. Easily below that then is a signature that I see of Austin Trent, and is that your signature I'm looking at? And when did you sign this agreement, Mr. Trent? I'm sorry. All right. And before you signed it, did you go with your attorney and have her explain it to you and discuss what you wanted? And you understood that when you signed this agreement, it means there's not going to be a trial. The next step in your case would be a sentencing hearing. Then now speak up.
Yes.
Okay. And is this something that you had thought might be possible to came here today after your discussion with your attorney about your case? Yeah. Right. So you're not surprised or rushed in any way about this? Get quickly doing this thing. Okay. So you entered into this agreement voluntarily? Now, the agreement states you're going to withdraw your non-guilty, plead guilty to the charge in count 1. Aggravated trafficking in LSD, under 2925.03 and 1, a 4-3 felony. Further states that you understand the maximum penalty for this could be 18 months in prison, the minimum would be 6 months in prison term imposed. There could be a fine of $5,000. There is possible license suspension, 6 months to 5 years of work. Are you facing a felony charge in any other jurisdiction?
Not that I'm aware of.
Are you currently on probation, police control, parole, social control, or any kind
Probation.
from where?
Okay.
Is this this case? Pre-trial supervision? Okay, not any.
Well, miss.
All misdemeanors? Okay, no felonies. Okay. Right. Now, under the law, Mr. Trent, if you were convicted of this offense, and if you were sentenced to prison, once you complete the prison term imposed by the court, the law provides that the adult parole authority may, as their option, place you on what's called close release control for a period of up to 2 years. They don't have to, if they can. If they do, you'll be supervised on the terms that they set, because the court has to involve that. And if they determine during that period of time that you have been confined, they can return to prison for an additional period of, in this case, up to half of the prison term, one or more violations. But committed a felony while in post-release control supervision, and an additional term sentence imposed by the judge for that new conviction. That judge can also sentence you for committing that crime while under post-release control. In this case, probation period 1 year, whatever time after left on that post-release control supervision. Whichever greater occurs as for secondly, the sentence in the case. You understand that? Under the law, I'm required to sentence you to prison for this offense. I can impose what's called complete control, or those people know to be probation. What that means is that instead of going to prison, you'll be put under the supervision of a probation officer under the terms set by the court. Yet during that period of time, the department felt that you were not following the rules, that they could file a written notice at the court, and they would copy on you, then you would have a hearing. The outcome of that hearing was that you had failed to comply. At that time, they would, then the court would revoke your control and send you to prison for 18 months and fine you $5,000. You understand that?
Yes, sir.
Right now, the charge in this case, count 1, alleges that on or about June 25, 2020, Huntington County, Ohio, he did knowingly sell or offer to sell LSD, Schedule 1 controlled substance, and amount equal to or exceeding 10 doses, less than 60 doses, violation section 2925.0381, charge of trafficking in LSD, 4-3 felony, penalties not prescribed. Do you understand what it is you're charged with, what the state says you did, when or how they let you do? Discuss the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise a trial, possible outcomes of the trial with the attorney. Are you satisfied with the advice and confidence in the matter? Or advice and confidence in the matter? Are you under the influence of any type of drug or alcohol at this time? Are you taking any prescription drugs? Again, keep your voice up. You're really soft focus. Okay. Right. Now, on page 2, there are 3 lines printed bold and underlined. So I'll read those at this time. Defendant shall enter plea guilty to count 1, state dismiss count 2. State defense joined the recommended controlled substance abuse treatment. Defendant agrees to pay $160 restitution to the Huntington County Task Force as consideration for this recommendation. That's your understanding of the agreement. Does anyone want to say anything other than if you plead guilty or not? Under the law, matter of sentence is up to the judge, not the party. So even though there's an agreement as to what the sentence should be, in the event that you plead guilty, the court determines that's not the correct sentence, I could go ahead and send you to prison for up to 18 months, fine you $5,000, and have to spend your license for 6 months, 5 years. You understand that? Now, do you hold any license or certification from any state agency, governmental agency that regulates any kind of trade or occupation? And now, under the law, we have certain rights in the Constitution you must understand before I can set the plea guilty. First, you have a right to have an attorney that's looking for and represent you, not simply work the case out, but to provide any defense that could be available to you under the law that you like to provide. So if you decide you don't want to plead guilty, that you want to defend against this case, she'll continue to represent you with the agony trial, if that's what you want. You understand that? Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected, a group of citizens that live in this county that are subject for jury duty under the trial. After they are selected, the evidence will be presented, they will be instructed on the law by the judge, and they will decide whether or not to state truth or guilt. And that decision would have to be unanimous, meaning all 12 have to agree on the verdict. Now, if you decided you didn't want to have jury trial, but you did not want to plead guilty, then you could waive the right. You could waive in that sense means to give up the right to have a jury trial. In that case, you would have what's called a court bench trial, meaning it would be the judge instead of the jury who would hear the evidence, apply the law, decide whether or not to say truth or guilt by proof of that. You understand that? Now, under the Constitution, Mr. Trent, you have a right to confront the witness against you and cross-examine through your attorney. So what that means is the witness against you have to be in court testify in front of you and your attorney and anyone else that might be present. After the prosecutor can ask you questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that? All right, under the Constitution, you're presumed, you have a privilege against self-determination, which means that you cannot be forced to give evidence in this matter at any time before the trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation, that is, if there's a jury trial, and you don't testify, the judge instructs the jury that process your right, they cannot consider it for any purpose. You understand that? The Constitution, you're presumed innocent and proved guilty by the state of Ohio on every sense of the offense charged by proof beyond reasonable doubt. What that means is the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence in your own defense at trial. You may, it's not required. Whether you do or not, the burden of proof will remain upon the state to prove your proof beyond reasonable doubt on every sense of the defense charge, which is the highest burden of proof known under the law. You understand that? Originally, you pleaded not guilty to this charge. Trent pleaded not guilty, denied the allegations of the indictment, denied you committed any crime. That exercise your vote on the rights I just described. Change your plea today from not guilty to guilty, that is the opposite of not guilty. Admit the allegations count one. Admit that they constitute crime, and that you committed that crime. That plea waives gives up all the rights that I just described for you here today, except the right to have an attorney. You always have the right to have an attorney no matter what you plead. That is second. Your plea of guilty. Waives gives up your right to have a jury or a court trial. Waives gives up the right to find witness against you, cross-examine for your attorney. Waives gives up the right to use the power of the court, compel the force witness to court to testify on your behalf in the same state. Waives gives up your privilege of self-determination because the same rules which you apply to. And waives gives up your self-innocence because if you say you're guilty, the state doesn't have to prove it. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file appeal that you think you may have up to this point in the case. Now, if I sentence you the maximum sentence or a certain circumstances to file appeal, they'll have to file within 30 days if your sentencing entry be filed. You understand all that? Are you a U.S. citizen, Mr. Trent? Do you have any questions about the charge of the penalty? You understand it? Any questions about the plea agreement? Understand it? Any questions about the constitutional aspect claim? Understand those? You keep your voice up. Yes. Do you have any questions on the plea of guilty, what it means, what will happen in that plea today? You understand? Anything you need to speak with your attorney about before we go further? Is it your decision then to withdraw your not guilty plea guilty if you can't want for the term of this plea agreement is over? Alright, then that's count one, which alleges that on or about June 25, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule 1 controlled substance with LSD and amount equal to or exceeding 10 unit doses of less than 50 unit doses. Violation of section 2925.03A1, the charge of trafficking LSD, a 4-degree felony, carrying possible prison term between 6 and 18 months, a fine of up to $5,000 and a possible license suspension 6 months to 5 years. Thank you. Court finds on this date of the court defendant advised all his constitutional rights and in one intelligent voluntary written sentencing criminal 11, please accept the court 5, defendant count 1, count 2 is dismissed. Court ordered a pre-sentence investigation which shall include an assessment for the substance use disorder and or mental health issues. The matter will be set for sentencing on June 1st at 9 a.m. You see the probation officer over here to arrangements to have a pre-sentence interview so they can get their information from you that we give. Alright, is there anything further counsel?
No.
Alright, let's go ahead and see the probation officer. Thanks. Lee Robinson. Case number 22, CR 57, State of Ohio versus Lee, Aubrey, Lee Robinson. Present for the state's prosecutor, Collins, medical captain, Cat Packer, and your Lee, Aubrey, Lee Robinson.
Yes, sir.
All right, Mr. Robinson, start on defendants. Total 10 counts. Mr. Robinson starts on 10. All right. Yeah, this is on a pre-trial trial set for now. Discovery legal side.
Your Honor, this, for Mr. Robinson, is a final pre-trial, but I was only recently appointed, and this is the first time that I've appeared in this case.
Oh, yeah, that's right. Okay.
As far as, well, so I've not really had much of a chance to speak with Mr. Robinson or get witnesses from him, so I don't believe that I have applied for discovery yet.
Well, I'll give you 2 weeks in. I'll give you up to the 18th also to file any motions.
And you said that the trial is scheduled for May 31st. I actually have conflicts that day, so if we could continue that, if it's needed.
Yeah, we'll get him off before, and I don't think he's in jail.
I think he was in jail at the time of his first free trial and bonded out.
I don't know, in jail for 30 days. Oh, 1 day.
Yeah, so time should not be.
So we should have an speed trial off. So if that's necessary, sure you want your attorney to be prepared and be able to have it on. Get that as necessary, probably. Probably spend it for about 30 days. All right, anything further?
No.
Do you need to see probation sent or this morning? Or you can check in on the way out then, right?
The state has provided a written plea offer.
Okay.
And I have discussed that with him, but only within the last day or two. So.
Okay. I didn't know if got to get another return previously. All right. All right. Anything further?
No, Your Honor.
All right. Thank you. See, you got another one?
Yes, I've got Devin Sparks.
All right. Kevin Parks. Case number 22, CR 22. State of Ohio versus Devin Sparks. President for the state, Attorney Collins, also Dr. King, Packer. Devin Sparks.
Yes, sir.
All right, Mr. Sparks is charged. Looks like it counts 17, 18. Along with several co-defendants. Charged in that case, aggravated traffic and study, school book, aggravated study. I think that's what you charge there.
That's correct.
All right, final pre-trial, round 87, May 1st. Now, discovery complete in this case.
I believe it is, Your Honor.
All right, and we filed a pre-trial.
I have not.
Okay. And there's a plea offer provided.
I'm sorry, yes, there has been a plea offer. I have gone over that with my client. He is not rejecting that offer, but here's the issue that we have. There's video, which has been marked for counsel eyes only, and my client believes, and I agree with him, that in order for him to make an informed decision as to whether he wants to plea or go to trial, he needs to be able to view that video. And I have not been able to let him see that at this point because it's been marked counsel eyes only.
Okay. I assume that's because there's a form on it.
That's correct.
And that form has been edited and reviewed.
No, it's not.
Well, generally, most of the court is that, the matter to be disclosed if matters of the trial. I understand the issue, but, you've seen the video, I would assume, and if you tell him what you've seen on it, yeah, I believe that. Because, of course, it's concerned about making sure that the person's identity is not confirmed publicly or protected on an issue in facts, particularly when you have on social media. And so that's the reason that the prosecutor does it. That's the reason the rules there. So, I guess we'll have to make a decision whether he wants to see it bad enough and wants to go to trial, or he wants to rely upon advice and counsel.
I mean, I'm not suggesting that I make a copy of it for him, but that he'd be able to come to my office to view it, and he wouldn't leave my office.
Well, and again, he'll be able to do that at prison. So that's the situation. Now, are there any other matters we need to discuss?
No, Your Honor.
Yeah, well, there is one report of you. Mr. Sparks, I have here a report from the probation office that since I first put in pre-trial supervision in 2009, it's probably the longest non-compliance report I've seen on both testing positive, metadata and 1, 2, 3, 4, 5, 6, 7, 8 times since March 9th, and not hearing their appointments on 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 times. Called in once on April 13th. Since March 24th, we were on the call-in system to go to testing positive. And before that, it's according to Cytopenic Valley, you haven't had contact with them since March 24th. You were sent a report or asking you to close that appointment with them tomorrow. So you have been reporting, but you haven't been coming in for drug testing. So we're report on bail as far as report for testing when that is right.
Right, I'm gonna get all that straightened out. I'm going to FRS tomorrow. I'm gonna be in treatment there. I'm going to tomorrow and every day. And,
I just want to give you this report. Officer I over here, he's in charge of this program. That if there's one more time that you fail test you're supposed to, or you fail to report, then the court is going to order you to be taken to custody.
yes, sir.
But you comply with the court.
Yes, sir.
All right. Now, anything further, counsel?
I think the only other issue is that I think he's also scheduled for trial on May 31st. And I had the same.
I thought it was yeah, and how long was he in jail before release?
Oh, what that? A week?
Yeah, it wasn't a terribly long
Looks like
time.
it was a bond was filed on February 10th. And he was died on the 1st. So. All right, so there's not a speedy trial complication. All right. So, in the event that becomes necessary, we'll see. But give you till the 17th, 2 weeks prior to the send that. All right, thank you.
Thank you, Your Honor.
Thank you. All right, Hatfield. Case number 22-CR87. Case number 22-CR87. State of Ohio versus Carl B. Hatfield. Federal State, Dr. College, Dr. King, and defendant, Lit. You are Carl Eugene Hatfield.
Yes, sir.
All right, Mr. Hatfield was charged with 8 count indictment, the current count actually trafficking and possession of possession of drugs. This is the first pre-trial, final pre-trial set on the 1st of June. have a trial date set on June 16th. And CNC will meticulously provided, and also a discovery. And have you provided your discovery yet?
Not yet, no.
Alright, yours will be provided on pre-trial. And anticipated pre-trial motion.
No.
Alright, and the written plea offer provided,
Yes.
certified where.
Yes.
Are there any other matters that need to be discussed then?
No, Your Honor.
Alright, then we'll see you back here on the first. Keep the court information as well. Alright, Kathy Sparks. Case number 22, CR 24, State of Ohio versus Kathy Sparks. Kathy A. Sparks, President of the State. Prosecutor Collins, Prosecutor King, President of the Defendant, Daniel Witt. Are you Kathy A. Sparks?
Yes, Your Honor.
Alright, Ms. Sparks is charged along with several co-defendants. She has two counts of country employee, actually trafficking, student school, and possession. And also counts 27 and 28 with committing drug use. This is a pre-trial and a trial date set for May 3rd.
May I approach?
Right. Alright, Sparks has been presented with a plea of guilty form. In case you're going to withdraw, not guilty plea, includes both amended charge count 19 and count 27. This is a 3-page document to the prosecutor's office. On page 3, there's a sentence about halfway down the page that says that it was plead voluntarily. Immediately below that is the signature line that appears to be the signature of Kathy Sparks. This is your signature I'm looking at.
Yes, sure.
And when did you sign this document?
Earlier, before, when I came into it.
Alright, when you signed it, before you signed it, your attorney go over the explanatory to you?
Yes, Your Honor.
Did you understand when you signed it that it was agreement to plead guilty, which means there won't be a trial, next step in your case will be sentencing hearing?
Yes, Your Honor.
And this is something you thought might happen when you came here today from your previous discussions with your attorney?
Yes.
So you feel you could rush or pressure in any way to make this decision today?
No, Your Honor.
Are you pleading, everything you do, plead guilty voluntarily?
Yes, Your Honor.
Now, the agreement states on page 1, plead guilty to defendant count 19. Count 19 is alleged, is aggravated trafficking methamphetamine specific school zone secondary felony, which carried in for a prison for 2 years. Now, that charge can be amended to a third felony, and I assume that's by the lead of the vicinity of the school zone. You're leading the vicinity of the school zone, count 19, reduced by 1 degree.
Yes, Your Honor, I'm sorry.
Alright, okay.
I'm sorry, I apologize.
Right. Now, so what that does is that reduces that down from a mandatory 2 to 8 years prison term to a non-mandatory term of 9 to 36 months. And the entry provided by law starts at 9 to 12, goes every 6 months, up to 36 months. And then count 27, we go with that as charged, which is drug abuse, 29, 25, 14B, higher by slope, that's a 5th-degree felony. Now, as far as count 19, as I said, the prison term is 9 to 36 months, and provided by the statute. Fine level of $10,000, mandatory fine $5,000, possible license suspension 6 months to 5 years. I'm not required to sentence you to prison as charged. I would be, but this one I'm not required to, although there's still a presumption that there ought to be a prison term, but it's not required. And it's count 27, maximum prison term is 12 months, minimum is 6 months. There's a possible fine of $2,500. There's also a possible license suspension 6 months to 5 years for each charge. Do you understand that?
Yes, Your Honor.
You should be sent to prison for these offenses, Ms. March. those sentences could be ordered to serve consecutively, one after the other. So adding up the maximum on count 1 of 36 and the maximum on count 27 of 12 is 15 months would be the maximum. Adding the 2 lines together would be $12,500. You understand that?
Yes, Your Honor.
Under law, as far as if you're convicted of these offenses and sent to prison and served the entire prison term, once you complete that prison term, the law provides that the adult parole board may, at their option, put you under post-release control for a period of up to 2 years. They don't have to, but they could. They do. They would supervise on the term they set by a parole officer, and if they determine that you have failed to comply with those conditions, they can return you to prison, even though you served the entire term controlled by the judge, for an additional period of up to 9 months for one violation. Half, or limit of half of their prison term for all violations. However, if you committed a felony on post-release control supervision, and in addition to whatever sentence the judge, the new case could impose upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater, that period that would have to be served consecutively to the sentence in the case. You understand that?
Yes, Your Honor.
Right now, under the law, as I indicated, not required to send you to prison for these offenses. So I put what shows called community control. That's a non-prison sanction, which means instead of going to prison, you put a supervision of a probation officer for a period of up to 5 years. Now, if during that period of time you were being supervised, the probation department felt that you were on, would have to file a written notice at the court. It would be a hearing that you get a copy of it. And you would be entitled to be represented by counsel. If the outcome of that hearing was that you failed to comply, then at that time, the court would revoke your community control and then send you to prison for 48 months of time, $12,500. You understand that?
Yes, Your Honor.
All right, now, count 19 as amended. Read it as follows. That on or about June 24, 2021 in Highland County, Ohio, Jennifer R. Eisen and you did knowingly sell or offer to sell methamphetamine and Schedule II controlled substance of amount equal to a receiving bulk amount less than 5 times bulk amount. And the rest of it will be illegal. That be violation of 9.5.81, charge of aggravated trafficking in methamphetamine. Count 27 alleges that on or about June 23, 2021 in Highland County, Ohio, the area as far as you is the owner or lessee, occupants of, or the persons in control, custody, or supervision of the premises located at 820 Marylebone Street, Greenville, Highland County, knowingly permitted the premises or real estate to be used for commission of a felony drug offense with aggravated trafficking of methamphetamine and aggravated possession of methamphetamine by another person with Jennifer R. Eisen. And that'd be a violation of section 125.13b, committing drug offense. Now, as far as you understand what it is the state's accused you having done those 2 counts that they say you did when we're out alleged it.
Yes, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses might try to raise a trial, the possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with their advice and confidence in the matter?
Yes, Your Honor.
Are you under the influence of any type of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
Yes, sir.
Do any of them interfere with your ability to understand what should be told, or express your thoughts clearly and understand what's going on?
No, Your Honor.
Have any threat made to the ability here today?
No, Your Honor.
Now, on page 2 at the bottom, there are about 6 lines that are printed and in bold. And I'll read those as follows. Finish letter pleading guilty to count 19 as amended and count 27. Amendment state was list remaining counts. Date defendant is going to be recommended 36 months on count 19, consecutive 12 months on count 27 for a total 48 months incarceration, state upon opposed, judicial release of the STAR program after 6 months. Finish on pay restitution, the amount of $120 from several again for Eisen. Then shall cooperate fully with the defendant and the county. That's your understanding of the agreement.
Yes, Your Honor.
Does anyone promise you anything other than that in case you plead guilty here today?
No, Your Honor.
All right. Right now, so the recommendation here is for the maximum sentence. So if I were to follow that, I'm not required to, so I could be, that's not appropriate. But also should understand that if you are sentenced, it's a matter of judicial release and up to the judge. So even though there's an agreement that the state's not in opposition, if you are sentenced to prison and applying for judicial release, there's no guarantee that I'll make that decision based on information that we have at the time. You understand that?
Yes, Your Honor.
Now, other than that, is anyone promise you anything in case you will be here today?
No, Your Honor.
Right, now, do you hold any license or certificate from any state governmental agency that regulates any occupation, trade, or profession?
No, Your Honor.
You have certain constitutional rights, let's understand, or technically. First of all, you have right, or you have right to counsel, and I wanted to represent you. That wasn't simply for the purpose of working the case out, but to provide any defense that could be available to you under the law, she was to provide. So we decided not want to do this. She wanted to defend this charge. We'll continue to represent you, defend you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
All right, now in the Constitution, you have a, I'm sorry, you have a right to jury. What that means is that 12 people will be selected, citizens that are summoned for a jury duty on your trial date. After they are selected, the evidence will be presented. Then they will decide whether the state proved guilt beyond reasonable doubt after they receive the instructions of the court. Now, if you did want to have a jury trial, if you did want to be guilty, waive in writing, which means give up, right to have a jury trial. In that case, you have a court trial, meaning the judge will want to hear the evidence instead of the jury. The judge will apply the law, the judge will decide whether the state proved guilt or not proved guilty of that. You understand that?
Yes, Your Honor.
I don't know if I said it or not, but the jury trial requires unanimous verdict from all 12 before they get conviction. You understand that?
Yes, Your Honor.
Now, the Constitution, you have a right to use or confront with some issues, cross-examine your attorney. So what that means is that there's some issue that come in before we testify and review your attorney and anyone else is present. After the prosecutor then asks you questions, your attorney will ask questions. That's called cross-examination. The first that is very evidence developed on your side of the case. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of the court, or forcefully come into court to testify on your behalf. Same as the state. So if you have a witness and you're uncertain voluntarily, you request for issue for order from subpoena, and of course, the witnesses come to court, we don't testify if you want to. Whether they want to be here, which is the same way the state's witnesses are required. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a privilege and self-determination. You cannot force you evidence in this matter anytime, including trial. So don't ever make a testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify, you're not using it in any way by any person at any time. And in fact, no one's even going to talk about it except in one situation, there's a jury trial, and no one testifies. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you are presumed innocent until proven guilty on the state of Ohio on every essential element of the offense charged in these two counts. So what that means is that the burden of proof is on you to try to show you're not guilty simply because you're accused. In fact, under the law, you don't have to provide any defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt by proving beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that is known under the law. You understand that?
Yes, Your Honor.
Right, now, originally you entered a plea of not guilty. Guilty plea denied the allegations in the indictment and denied that they constitute crime and exercise or revoke all of the rights that I was planning for you this afternoon. If you change your plea to these two counts to guilty, that is the complete opposite of not guilty. Guilty plea would admit the allegations in the two counts of indictment of count 19 and admitted to the allegations constitute crime and then you admit the crime charge in those two counts. And that plea waive give up all the rights that I just described to you today, except the right to have an attorney. You always have the right to have an attorney. Come on, what's your plea? Well, that exception, your plea guilty waives gives up the right to have a jury report filed. Waives gives up the right to properly issue cross-examine your attorney. Waives gives up the right to use power of the court, tell the court witnesses in court, testify on your behalf of the same mistake. Wage gives up their privileges to self-determination, but the same ability to choose punishment. The wage gives up the presumption of innocence, because the same ability to state not required to prove. It also subjects you to the sentence to be by the court, but the court gives up the right to decline it. The wage gives up the right to file an appeal and any alleged violations of the rights you think may occur up to this point in the case. Now, if I should sentence you to maximum sentence, or under other circumstances, file it would have to be filed within 30 days of the sentencing hearing. You understand all that?
Yes, Your Honor.
And are you a U.S. citizen, Ms. Sparks?
Yes.
Do you have any questions about the amended charge of count 19 or the charge of count 17?
No, Your Honor.
You understand?
Yes.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand?
Yes.
Do you have any questions about the constitutional rights of the plea?
No, Your Honor.
You understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, what will happen if that plea here today?
Yes.
Any other questions first?
Oh,
Now do you understand?
yes.
All right. Is there anything you need to speak with Ms. Wood about before we go further?
No, I don't.
Any questions about anything we'll discuss here today?
No, Your Honor.
All right, and is it your decision to withdraw your not guilty plea, plead guilty to the amended count 19 and count 27 pursuant to the terms of the plea agreement this noted?
Yes, Your Honor.
Okay, then it's the amended charge in count 19. This would agree that on or about June 24, 2021, in Ohio, Jennifer R. Ison and you did not sell or offer to sell methamphetamine, is scheduled to controlled substance. The amount equal to exceeding bulk amount less than 5 times bulk amount in the vicinity of school zone, violation of section 2925. Illegal in the city school. In violation of section 2925.0381, a charge of aggravated trafficking in methamphetamine, a third-degree felony, carrying possible prison term of 9 to 36 months in provided by law, on $10,000 being awarded on $5,000 upon license suspension 6 months to 5 years. How do you think?
Guilty.
That is count 27. The alleged on or about June 23, 2021 in this county. Gary S. Sparks and you did be the owners, lessee, occupants, persons control custody of supervision premises located at 820 Barrow Street, Greenfield, Ohio. One made the premises for real estate to be used with permission of the felony road offense to wit aggravated trafficking methamphetamine, aggravated possession of methamphetamine by another person to wit Jennifer R. Ison, in violation of section 125.13b of the Ohio Revised Code. Any charge of committing drug abuse in a 53 felony, very possible for the church of the city of Broadway, or $25 authorized suspension 6 months to 5 years.
Guilty.
Okay, court finds on this day of the court has provided all the constitutional rights of the Illinois telephone fair to the section 11. Please accept the order filed and accountability of count 19 is amended and count 27 as charged. The counts 20 and 28 are dismissed. The court orders the matter to be referred to the probation department for sentence investigation. Bond will be continued and sentencing will be set to June 1st at 9 a.m. All right, is there anything further, counsel?
No, Your Honor.
All right, thank you. You can see the probation officer over here, regular PSI. Is there you, Mr. Parker?
No.
He's not here, Your Honor.
Mike.
All right. Hold on, are you his attorney?
It's Courtroom. Mr. Armstrong is Mr. Lightner's attorney.
For me, it's awesome. I still owe about $1 grand to him, so.
Pardon me?
I still owe him about $1 grand.
All right. Let's do it real quick and I'll do this with, Paul's report case. CR 54, State of Ohio. Lightner. We have to say that the attorney assistant not here. Mr. Armstrong is the defendant's attorney now. Is he under appearance date?
I don't have a copy of that, but he requested that he appeared at the first pretrial. He was not available to be here this afternoon. I think he probably just missed this on his calendar.
Oh, okay.
Because we moved his other case that was set for today to yesterday.
Oh.
This price was set for today, and we moved it to yesterday for a pretrial because he was not available today. I didn't say he just missed it.
All right. Well, he's still your attorney, and I must be what's going on. I wondered why I was, okay. Well, then what we're gonna do is we'll call, the Attorney Office will get another date set. I'm sorry I said it today. I thought, maybe we had wanted to sort of name the docket. So, we'll probably send it sometime next week. All right. We'll just leave the probation on the way out. All right, now, Mr. Parker, or Dr. Parker. All right. Case number 21 CR 205. Is Mr. Joshua P. Corcoran. President of the United States, Prosecutor Collins, Prosecutor King, President of the United States, West. Steve said 1 o'clock, almost 10 to 4 now, back to the block this afternoon. That is not present. We see,
Set 2 o'clock.
on the probation department that he was arraigned on an indictment in Warren County. The prison picked up the right suspension of possession on April 27th. It says he was transferred to Delaware County. They housing prisoners from Warren County.
No, it's,
Yeah, so let's do that one.
it's from,
Where?
Edinburgh, maybe?
Okay, but it's in Delaware County? Oh, okay.
So once you reach Delaware County, you go back to Warren.
Okay, this came in late afternoon, this, I didn't see it this where it's out today. He is in custody. Oh, so good. Okay.
His mom called our office and told us the same thing.
All right.
And we told him to call the court, or told her to call the court and just quit.
All right. I'm going to order a whole replacement because, so we can get him back here. When it's available, or once we're good, get back here. This is changing. So, all right, we'll see what happens.
Okay, thanks. Judge, I have 3 of the 4 sentencing entries signed from this afternoon. Mr. Wagner's the only one.
Okay.
Do you want it or do you want me to? Okay.
Also tensions here, we and very and then there's also I said about 6.
Did a couple cases here. Got Corey Hatfield goes to Friday. Bill or JD. Now What happened?
He
We had
was
a
out
couple.
on Alan Green, I think, also.
Yeah.
It was Friday.
Carrie Price
They
and,
did her yesterday.
That's
okay,
exactly right. He's too arrogant.
the daggone clerk's office doesn't move crap, and then Kramer, Harold Kramer.
I'm sorry, it has been longer than that. He's been out for 2 years.
Harold Kramer.
Yeah.
He's already pled. I don't know if he's been sentenced or not off the top of my head.
Okay. Well, he was up for,
I know originally he was set for like today or maybe. And, yeah.
final pre-trial.
Yeah. He definitely already pled. I just can't remember if he's been sentenced yet.
Okay. Thank you.
But it is a crime. I'm watching it right now. I love it.
I recommend it.
I finished it. I watched the second half.
New episode. Yeah, the new episode just came out.
I watched them all.
Did you already?
So this is in
Yeah.
yeah. But so that's why she just can't.